Yes, sir.
Hope my audio is audible, ma'am.
Yes, sir.
Okay, thank you. Can you see my screen, ma'am, by any chance? Can anyone confirm like that you can see my screen?
Yes, sir.
Yeah. Thank you, ma'am. Good afternoon, everyone. Welcome to our session on integrating IBC with labor laws and Companies Act. So, in today's session, we will be dealing with no IBC alongside labor laws. Sorry, sorry. Yeah. So in today's session, we will discuss about the integration of IBC alongside labor laws. While in tomorrow's session, we will deal with IBC vis-a-vis Companies Act. Now, on earlier occasion, also had the opportunity to take up the sessions on IBC alongside labor laws and Companies Act. For the today's session, I've come up with much more practical insights from my recent experiences in certain going concern matters where I am actively involved in assisting the RP, and in couple of going concern matters where I am the RP myself. So that's exactly what we are going to do today, and subsequently, I'll also be happy to take up any questions, any practical insights from the insolvency professionals who are attending this session. I always, believe that typically the crux, I mean, the best of the discussions happen when we all speak from our practical experiences and share those thoughts in the meeting. And then when all of us put together, provide our insights, I think more or less we always come up with some solution. So that way, I request all those who are attending to actively pose questions. I might have answers, I might not have answers, but for the larger good of discussion, that would always be a great starting point. So, with this brief backdrop, I'd like to step into our first session today with respect to IBC and labor laws. Now, with respect to IBC and labor laws, there are multiple scenarios which we need to keep in mind. And to the extent of what I could recollect is in terms, I mean, from my personal experiences, the stages where this labor law knowledge is of importance to us starts with firstly and with most importantly the verification of claims stage. So when you are verifying the claims, not just of the employees but also of authorities like that of Provident Fund, ESIC, I know the knowledge on labor laws will always help in understanding how these claims have been submitted. Like for instance, 7A assessment, 7Q assessments, estimates, and orders passed by PF authorities based on the estimates provided by you know sorry yeah, so based on the estimates provided by the company, all these the knowledge on how these PF dues are computed or how the PF interest and damages are computed will help us in understanding. I mean, the knowledge on labor laws will help us in making sure that the claims are verified properly in accordance with the law. So the first stage where typically all IPs today have a knowledge, I mean, face this issue in terms of labor laws is in terms of verification of claims. Typically, Provident Fund authorities submit their claims basis their assessment orders, and at times they only submit estimated claims. Now, our knowledge on IBC and our knowledge on labor laws together can only help us in identifying how we can verify these kind of claims. So that is the stage one. Second stage is during a CIRP and during liquidation, if at all the company is a going concern. So if the company is having operations and you are at the helm of affairs as a RP, because all the powers of the board of directors are suspended and you have been vested and you will exercise such powers of the board of directors. So therefore, the one in charge as per the labor laws would come down or boil down to a resolution professional. So during the CIRP or liquidation, if the company is having running operations, that is a stage where, as resolution professionals or as insolvency professionals, rather, we have got much more responsibility to understand what level of compliances are mandated under the labor laws, and particularly in terms of the recently introduced or rather recently enforced the labor codes with effect from November 2025, the four labor code which we have in force, and also the central rules which were notified as latest as May 2026. So an awareness of these amendments and changes and the reforms introduced in these labor law legislations is of extreme importance, particularly for those RPs who are running units or rather who are conducting the CIRP of corporate debtors which have running operations. Now, I mean, there's a need for us to spend a minute more on understanding how this running, I mean, companies with going concern, how relevant is ensuring the compliance with the labor laws. Now, see, let me quote an example so that that can give you a better idea of how this can be impactful for the resolution professionals. Now, there is a concept called occupier, right? So, occupier, that is a concept only pertaining to the labor laws, right? As per the Factories Act earlier, and now as per the Industrial Relations Code, there you need to have a occupier in place. Now, what is the role of the occupier? So, occupier should essentially be one of the board of directors of the company, and the role of the occupier is to ensure that all the laws pertaining to safety or anything in terms of the labor law compliances should be strictly complied. And then in addition to that, the one important thing is if there is any accident, if there is anything, any harmful activity and being done in the factory, the first one to be made responsible is the occupier. Now, in one of the matters, while I was working with TNY, where we were assisting one of the RPs, we have come across a notice from the from the factory. I mean, the Department of Factories state at the time we applied for renewal of labor license. Sorry, renewal of factory license. So we received a reply from the department stating that since the IBC has been commenced, and the powers of the board is suspended, it is the RP who is now exercising the powers of the board. So the RP's name should be nominated as the occupier and not that of any other suspended board, is what the department had communicated. Now, is it the case across India? I don't think so, because as one thing we need to understand is we are dealing with the authority which has spread its wings across India, across districts and across various zones. So every zone they have their own way of dealing with the factories. They have their own way of giving licenses and approvals. Of course, there are other matters where in fact, where I was the RP, we continued one of the directors as the occupier throughout the process. But there are some cases where the departments are insisting for the RP's name to be provided as an occupier. So now this, why exactly this occupier as a role becomes difficult or rather important is because if there is any accident or if there is any any harmful activity in the factory, it is the occupier who will be firstly arrested or immediate criminal action will be filed against them. And as you know, the way these kind of criminal actions are dealt with in India, it will take years together for us to go keep on going and fighting this case, because a criminal case is filed not in your capacity as a RP but in your individual capacity, because it is considered as a negligence, and therefore we need to prove beyond doubt that from our side there was no negligence. So it is an unnecessary burden for us on an individual level to fight such kind of litigations. So therefore, having study knowledge on labor laws and how it impacts a company's operations, how important is safety for a workman in the factory, and in order even for us as RPs, we should do thorough site visits to see if the facilities are safe enough for the workmen to function, and if there are any injuries ongoing, what kind of policies are in place, what kind of insurance is in place to protect such kind of damages or such kind of accidents happening to the workmen. All these are things which we need to, in general, as RPs, we need to have some level of awareness about that. So particularly from the point of view of companies which are running operations, I honestly feel that as RPs we need to have thorough knowledge of how these labor laws operate, and if needed, we should even try to bring in a consultant in place who can advise us on whether the existing labor law compliances done by the company are sufficient enough or not, right? So that is how that's how I would see the integration of IBC with that of labor laws. But if you talk about companies where there are no operations, no employees, the factory is shut and just lying idle, only responsibility for us would be to ensure there is no harmful activity happening in the factory premises. The factory is safe and secure from any antisocial activities. And if the factory contains certain chemicals which are dangerous enough, then we should ensure that they are adequately contained and that the same are not being released into the nearby villages or the facilities. So such kind of awareness we need to have in place, and such kind of compliances we need to put in place to make sure we are compliant. Otherwise, there is no major issue for companies where there are no operations. And one other issue which I miss, like in terms of companies which have operations, is regular compliances. Like you have employees, workmen, you're deducting PF, you're deducting ESIC, and you are depositing it with the departments. Now everything has become online. ESIC as well as PF, the challans which you generate for making the payments will also be through the online portals. So some level of understanding. Of course, since it's a running company, we will obviously have a team of resources helping us in doing the labor law compliances, no doubt about it. But nevertheless, from the insolvency commencement date, we should ensure that all the PF liabilities are at least adequately deposited without any failure, irrespective of whether they have been deposited prior to the CARP or not. But during the CARP, we should ensure that they are being adequately deposited, and we should write letters to the PF authority requesting them not to adjust such deposits against any previous dues. Anyways, we will do it based on the challan, but nevertheless, we should give it in writing to the PF authorities stating that these amounts which are being deposited for post CARP PF dues should not be adjusted for any pre CARP dues. So PF returns on monthly basis, ESIC returns, and final annual returns of both PF and ESIC. These kind of regular compliances have to be thoroughly ensured. Right. So this is just a backdrop within which we will be discussing during the meeting today. So I would be focusing more on certain key issues which have an impact during the CIRP. Yes, as we move forward, firstly, why is it that the labor law sits at the heart of the insolvency, right? So again, the context is where we have operations as a going concern, right? So where we have workforce, it means there is a going concern in majority of the cases. It might be the case in some cases where we have workforce, but we don't have any business. The company is continuing to have employees, maybe paying them some partial amounts, and keeping them intact, but there is no business. That might also be the case. I had no wonder, right? So for sure, there might be certain case. Uh, there might be certain issue where we have employees. I mean, where we may have employees, but there is no business. So that is again a very standalone case. But in general, if you're having a workforce, it is as good as there is a going concern. And as per Section 20, we have an obligation to preserve the value and manage the operations of the corporate debtor as a going concern. And therefore, if without retaining and paying this workforce, we will obviously not be able to run the company as a going concern. So our obligation to preserve and value manage the operations as a going concern also includes retaining the employees and ensuring all their welfare. Now, second, again, this is a very interesting discussion or a debate to be made. Labor law is a welfare legislation, right? Whereas IBC is a creator driven one and it's a commercial legislation, right? Obviously, it's a commercial law which is dealing with settlements and haircuts, etc. So how do these two go together, right? Now, in this particularly in terms of IBC, what we need to strike is a balance between the two. See, on one side, obviously as per the labor laws, let's say the bonus has to be paid, which is mandatory, right? It's a mandatory bonus which you will pay now, but you know that the company is not in a position to make a payment of bonus. Then what do you do if your company is not in a position to make the payment of bonus? How do you carve a exception for it, right? It's these kind of issues, like what kind of compliances are needed for it. So just because we are under IBC doesn't mean, again, going back to in terms of reference to the role of the IRP, where it is clearly mentioned that IRP shall ensure compliance of all applicable laws. So IRP or RP, as the case may be, shall ensure a compliance of all the applicable laws, right? So that is what is the primary context within which we need to operate as RPs. Just because the company is under IBC doesn't give us immunity from compliances under other legislations, be it anything. Any legislation which is applicable and any compliance which is applicable to the company has to be complied. So, accordingly, though the labor law legislation is a welfare legislation and IBC has, an effect of it is notwithstanding any other law, right? As per Section 238, it overrides other inconsistent laws, even though that is in place. But a labor law legislation is not something which is inconsistent with that of the IBC, right? So therefore, we need to act in harmony to make sure how best the compliances are being done within the four walls of the IBC. For instance, like let's say a PF authority may start claiming for dues prior to the CIRP, which is this I have practically experienced in cases, particularly in Tamil Nadu, where PF authorities have written stating that their dues are outside the IBC, I mean, outside the liquidation estate, and therefore we need not submit a claim. See, I'm reading the exact language they've used. They've very clearly written in writing that a PF authority need not submit its claim. It is the responsibility of the RP to ensure that all the PF dues are paid, and you should pay it immediately. That is how we have received letters from the PF authorities. Now, these kind of things, obviously, as RPs, we have to read it in the four walls of the IBC only, because it is a claim and it is pertaining to the priority of PF dues. Now, what we need to understand here is, under the IBC, yes, it is a matter of fact that PF dues are excluded from that of the liquidation estate. And we have certain rulings also very clearly mentioning that whosoever be the resolution applicant who is coming in, or if it is even the liquidation while we are doing the distribution, the top priority should be that of PF authorities, right? So PF dues. So it's only PF dues, not the interest, not the damages, but the PF dues. So the PF dues is something which has to be paid in top priority, is something which has evolved out of the law. And yes, we will adhere to it. But that doesn't mean as an RP during the process I will make the PF payment or obligatory. No, it is an obligation on the resolution applicant, or it is an obligation subsequently during the liquidation process. So just merely because a PF authority imposes such kind of interpretations, as RPs, obviously we will have to read it in accordance with the IBC. But if it is something to do like a PF due arising on employees' salaries after the CIRP period, then obviously we cannot take reliance of 238 or any other provision. As I said, an IRP has to ensure compliance of such laws in place, and all the PF dues or ESIC or whatever be the labor law required regulations, all of that will become applicable on us, and we cannot argue otherwise. And yes, in terms of the need to have an awareness of labor law, one important point which I highlighted at the last is with respect to the exposure of litigation and disciplinary action. Right now, this I mean, you would have seen um, a great amount of litigations initiated in NCLT or NCLAT from the labor law unions, right? So that is one part of it. But apart from that, even before the industry, before the forum of factories, I mean the industrial disputes forums which are established under the recent labor law codes, even there is a high possibility of the workmen invoking such jurisdiction. We may still argue that it is the NCLT where everything has to fall in place. But with respect to labor law disputes, where there is a dispute in terms of the non-compliance of the labor laws, it is the RP who will be at the helm of affairs and will be targeted to see to it that the compliances are done. So there is a huge scope for litigation. And in fact, in a recent matter where I was assisting the RP, there is a issue with respect to gratuity, right? So the complaints were addressed by ex-employees through the public, the public forum for grievance redressal, which is established by the central government. Through that forum, letters were written complaining against the RP, and the source letters went to the PM office, president office, whatever. As many of you may be aware, it's a standard way of sending it to all top officials of the country, including IBBI. And then IBBI has started taking action against the RP, in the sense, of course, has not initiated any disciplinary actions, but has been continuously following up with the RP to see to it that those compliances or whatever has to be done has to be done. Like, they know that there is nothing wrong with the RP, but considering it's a labor law issue, considering it's an issue pertaining to the salaries or um, uh, sorry, yeah, considering the issues pertaining to salaries, so we need to ensure. I mean, considering that these issues also pertain to the wages or salaries payable to these kind of workmen, etc., and it all falls back again on the RP. So we need to ensure that these concerns of the workmen are given top priority before they are being escalated to a level where the government gets involved personally, because we generally see that for any labor law revolt or any strike lockout, the local ministries, the local unions always get involved, right? So yeah, so that is how that has been. I mean, we need to ensure that these kind of compliances are taken. I mean, taken high cognizance of, so that no non-compliance or no disciplinary actions are falling on the resolution professionals, right? So yeah, now let's look into certain IBC provisions which comment on how to, I mean, which comment on the labor laws or the workmen dues, etc. Right. So there is a section which explains, or rather refers the definition of workmen dues, like section 53, which provides for the order of priority of payments. As many of you might be aware, the past 20, I mean, the past for the dues of the workmen would stand on par with the secured financial creditors, right? So 24 months dues would be ranking pari passu with the secured financial creditors. Now, that particular section defines workmen dues to be as per the Companies Act. Now, as per the Companies Act, section 326 of the Companies Act 2013 defines this term workmen dues, wherein it defines it as inclusive of wages or any kinds of remunerations or uh, compensations or perks, PF, pension, gratuity, everything and anything can come under the workman dues. So as a workman, those dues will become top priority, right? Next, um, now, who like in the definition of operational creditor and operational debt identify that the dues from employees or workmen are considered as operational debt, and the employees and workmen are considered as operational creditors. So I think this clarity many of us already have. And yes, most importantly, the CARP cost, since any costs incurred in to ensure going concern status of the company are considered as CARP costs, even the wages paid or payable to the workmen can should also be categorized under the CARP costs. So therefore, thereby, after the insolvency commencement date, the salaries or the wages payable to the employees of the workmen shall be given or will be given the top priority by the resolution professional, and they shall have I mean, they shall be paid in priority to any other creditor as a CARP cost, right? So that is how relevant the workman dues become once the CARP is commenced. Then, as per Section 14, so Section 14 only relevance, though there is no direct reference, the only relevance is with in terms of moratorium, that any pending labor court or industrial tribunal proceedings should be considered as under moratorium, and there will be a stay on all such proceedings. Next, with respect to section 20 and 25, with in terms of duty of IRP and RP, so again, the duty to preserve value or manage the operations as a going concern lies with the IRP or the RP. So accordingly, that also includes taking care of all the labor law compliances and the labor law issues, if any, in the company, so that the going concern status is adequately protected. Right. So that is the idea. Next. Next, in terms of Section 36, yes. So Section 36 provides for a situation where, I mean, provides for a clause wherein, sorry, Section 26 provides for a clause wherein all the PF pension fund as well as the gratuity fund shall be excluded from the liquidation estate. The relevance of this is again extremely important. What is the meaning of? What is the relevance of the section stating that these will not be forming part of the liquidation estate? Is that typically, as per the doctrine of distribution, like in insolvency situation, this doctrine defines that for distribution, the entire assets should ideally be distributed pari passu among all the creditors, except if there is an order of priority provided under the respective legislation, right? So that is why Section 53 is come into operation, and the assets are being distributed in that particular manner, or the proceeds are distributed in a particular manner. But the relevance of Section 36 is that, or the other 36 subsection 4 is that these funds, that is the provident fund, pension fund, or the gratuity fund, should be excluded from the estate. So if the company, if at all the company is maintaining any provident fund separately, or a pension fund or a gratuity fund, the same shall not be available for distribution to other creditors. That is what is the idea behind this Section 36 subsection 4. The same shall be ensured to be distributed only to the eligible employees who meet the criteria for obtaining the returns from such funds. So these funds are untouched. There cannot be any creditor who can state that this asset has to be distributed to them because it is from their money that this fund has been created. No arguments can come in the middle of, or become prior to the attention of these funds. So as the section has clarified, these funds will not be part of the liquidation estate, and it is not a new legislation as such. One has to recollect, or maybe pay attention to the fact that this law, in terms of excluding the provident fund, pension fund, and gratuity fund from the liquidation estate, was also similar in the Companies Act when they were dealing with winding up, right? So under the Companies Act, when prior to IBC, when a company had to be shut down either voluntarily or by way of compulsory winding up, there is again similar process of liquidation. I mean, of course, there was no CARP, but there was a process of liquidation and distribution, which was taken care by the official liquidator. Now, the official liquidator also used to do a similar thing, that if there is a provident fund, if there is a pension fund or a gratuity fund, the same will be excluded from distribution. The same will be made available for those who are eligible for receiving the funds from that fund, and for other assets only shall be forming part of the liquidation estate, which shall be distributed to all the creditors. The proceeds thereof shall be distributed to all the creditors in the manner provided under Section 326, 327 under the Companies Act. But here for us, the manner is provided, the manner of distribution or the order of priority are identified and explained in detail in Section 53 of the IBC. Right. So whatever fund is been already in place in terms of provident fund or pension fund or the gratuity fund, only to that extent it will be excluded from the estate and made available to the creditors for distribution. So that is the whole idea of Section 36, subsection 4. This is one of the most important provisions of intersection between Companies Act and labor laws, right? So that is how important it is. Yes, as we move forward, Section 53, as this I think we have already discussed, Section 53, subsection 1, clause A is with respect to insolvency resolution process costs and liquidation process costs. So, if at all there is any workforce engaged by the IRP, RP, or the liquidator during the CARP or liquidation, they will be paid the full amount, right? Because it is part of the CARP, I mean, part of the CARP cost or the liquidation cost. So, that law is clear. They will be paid full amounts. So, that is 53(1)(a). Now, 53(1)(b) is in terms of payments to be made to workmen for their past dues for 24 months, that is for 2 years. And those dues will be ranking pari passu with that of the dues of the secured financial creditors or rather secured creditors. Now, see how importance, what kind of importance has been given to workmen for their past dues for 2 years period. Now, the idea of elevating the workmen and making them stand on par with the secured financial creditors is to give that importance to the protection of workmen dues, right? So as we are all we are aware how employees and their labor law reforms are important for any country, and particularly a country like India with so much population. It is important that all employees have adequate protection for their dues, right? Employees or workmen. So this is one such provision which kind of highlights that importance and provides for a top priority, right, to all the workmen for their dues prior, for the dues pertaining to 24 months prior to the liquidation commencement date. The same shall be on par or as pari passu with that of the secured financial creditors. I'm sorry, secured creditors. And then followed by that, Section 53, subsection 1, clause C, which ranks the employee's wages, which is for 12 months, right? So, workmen dues for 24 months are prior, has to be paid in prior, alongside the secured creditors. And with respect to the next level is the employee's dues for 12 months period, right? Now, if at all, let's say an employee's dues were pending for more than 2 years, or workmen dues are pending for more than 2 years, then what happens to the dues which are beyond what is protected under Section 53, subsection 1, clause, Section 53(b) or C? What happens in those situations? In those situations, they will come under other creditors, not other creditors, but other pending or remaining dues. So under Section 53, we also have a column that after all these dues are paid, any other remaining debt that will, even under that, if at all there are any dues in excess of what is prescribed or which is coming under Section 53(1)(b) or C, in such cases, the excess will be, I mean, such excess claims will be considered under remaining debt, right? So that's about it. And then, of course, Section 21 in terms of COC meetings, yes, there cannot be any participation from workmen in the COC because of because the COC shall mandatorily comprise of all the financial creditors. However, in the recent amendments, in the IBBA regulations, they have mentioned that top five largest operational creditors in value, and if there are statutory authorities, then top three in value amongst the top five, the first three should be the top three in value of the statutory authorities, and the balance two would be from the top five highest operational creditors. So they shall form part of the as they shall be joining the meetings of the committee of creditors as observers. Now, earlier before the amendment, there was a clear provision, even now, that if there are no financial creditors in the company, in such cases, the top 18 unrelated operational creditors shall form part of the COC, and they shall include mandatorily one representative from employees and one representative from workmen and employees. So, a representation in the COC comes only if there are no financial creditors. So that's about it. So these are certain provisions wherein the clauses with respect to labor law are being dealt with under the IBC. Yeah. Now, there are certain labor law legislations. Again, if there is a transition of the com- let's say we are RP of a company for last 3 years, then definitely we would have seen a transition of how labor law compliances are being done prior to November 2025 and after November 2025. Now, prior to November 2025, we had these legislations of Industrial Disputes Act, the EPF and the Provident Fund Act, basically the Payment of Gratuity Act, ESI Act, and Payment of Wages or Bonus Act, right? Now, under this, the PF Act obviously continues as is. The Gratuity Act obviously continues as is. It is the Industrial Disputes Act which is subsumed in the Industrial Relations Code of 2020, and the ESI Act also continues as is. And the Payment of Wages or Bonus Act also will be applicable. So only typically this Industrial Disputes Act has now been subsumed in the Industrial Relations Code, and as we were discussing, the four labor codes, that is the code on wages, social security code, and operational safety, and I think the OSH code. I'll just give you the full form. One second. The Occupational Safety, Health and Working Conditions Code, and apart from that, even the Industrial Relations Code. All the four codes have been made effective from November 2025. So these acts, I mean, these codes particularly provide for repealing of the earlier legislations like Factories Act, Industrial Disputes Act. There are multiple legislations which have been repealed in accordance with after the implementation of these codes. But it was only in May 2026 that the central rules have been laid by the central government, right? So now, more or less, majority of the notifications have come from the Labor Department in terms of setting up a fund for you know training of employees who are retrenched, and many such issues, the reforms whichever have been prescribed under the labor code, they are slowly and steadily they have notified everything in the month by the end of month of May, right? So now let's look into certain issues like that of first and foremost, right? So whenever we look into labor law, a major question which drives every professional is in terms of identification uh, of that person as an employee or a workman, like what kind of distinction it provides, because as we have already seen under section 53, if you are a workman and there are dues for 24 months, that dues with respect to the workman are considered on top priority pari passu in pari passu with the secured creditors. While if you're an employee, you are coming in down the stage next to the workman for your recovery. So it kind of is clear that workmen have been given top priority in comparison with the employees, and there is definitely a distinction of the same under the respective labor codes. So now let's understand what exactly are these definitions, right? So technically, the term worker or earlier workman has been defined to be, include someone who is doing things manually, who is skilled, technical, operational, or any clerical work, right? And in accordance with the IBC, if they are coming under the definition of a workman, they'll have to submit a claim in Form D for whatever dues they have prior to filing their claim, and they will come under the waterfall mechanism for the protection for 24 months dues. Next in line we have is other employees. Now, other employees would be those who are not falling within the definition of workmen, but particularly the managerial staff, administrative staff, or supervisory staff, right? So, like managers and above, vice presidents, presidents, directors, professionals who are engaged, like that of the company secretary of the company or the CFO of the company, they are all employees of the company or on the full time roles, obviously, and they are not coming under those who are at the factory doing things with skill which is needed for the manufacturing, right? Or then, of course, in terms of the compliances, uh, again, as per the CARP regulations, the form to be filed for filing of a claim either by employee or workman is the same, which is Form D, right? So, be it an employee or a workman, they'll have to essentially submit their claim in Form D with the RP. Now, this is I mean, the idea of discussing this is that, particularly from the RP's point of view or the compliance point of view, at the time the claims are being admitted, it is prudent to classify the claimants as employees or workmen, so that that can help in better identification of these priorities under Section 53. Yes. Now, in terms of Section 14, that is the moratorium, what kind of protection we can take under Section 14 in terms of the employee related issues, right? Now, one thing is clear, as we have already discussed at the beginning of the session, that if there are any suits or proceedings before the labor courts or tribunals or any wage any authorities under the labor law legislations, the same shall 100% be stayed, because the moratorium provision is powerful enough to stay any kind of an action against the company, right? And if there are any awards already passed prior to the CARP or any decrees already passed for which execution petitions have already been filed, right? Typically, we call them as EPs, right? So, if there are any execution petitions already filed or any awards already in place, the execution thereof will also be failed, or any recovery certificates are in place and you want to recover that particular asset by sale or whatever, even that is not possible. Any attachments you do also should not have been ideally done. So Section 14 is a powerful thing to protect you from all of these issues. Similarly, the authorities are barred from taking any legal action against the company for any non-compliances or shortage, any claims pertaining to period prior to CARP. So the PF or ESIC authorities also cannot take any investigative action against the company for the period during the CARP. Now let me pause here to maybe just throw some practical insights on how this moratorium at times is being ignored by these labor law officials. Right, even after the CARP is invoked, we often find notices issued by the labor law authorities for conducting hearings in the matters pertaining to PF authorities, right? So the reason what they quote is that these hearings are meant for them to conclude on what amount has to be claimed in the CARP. But typically, these kind of hearings wherein you are directing the RP to come appear and explain on positioning of data, right? So, for instance, recently in one matter, the PF investigative officers have visited the corporator's office, and they're insisting to meet the RP team. So, as an RP team, I have visited them and I was inquiring what kind of support they want from the RP. Not just because a claim, I mean, a company has been admitted into CIRP. Now, it seems the PF authorities have got their internal SOPs set in a way that all the PF authorities across that territory has to confirm if there is any claim to be filed or not. They have to concretely give a report. So, for which they have appointed these investigation officers to investigate as to whether there is any. I mean, investigation officers is not like some police, but of course, they have their own investigation officers within the EPFO to look into if there is any due payable by the company in terms for the prior period, right? So they have come up with a query that somewhere past in 2018 or 19, earlier to that, there was a PF registration in the name of the company in a particular territory, but subsequently they stopped making any deposits or stopped filing any returns. No, the reason is that that unit was sold to some other entity and the other entity had continued it. But for the PF authority, the system reflects there is one PF ID or a registration which was earlier done, returns were filed, but suddenly stopped to have been filed. So they take a safe route, firstly to ask information from us. Now, just imagine an IRP just stepping into the shoes and trying to get hang of things. Obviously, that will take a lot of time for him to understand if the company is not in operations. So, but if the company is in operations, then half of the time is dedicated on running the show, right? So, in such a situation, giving that kind of bulk information to the PF authority is also a problematic thing, right? So that's why PF authorities, what they smartly do is they send us notices couple of times, 3-4 times, and if we are not in a position to provide them with the data before that, then what they do hearings, right? So in the same hearing they'll do 3-4 hearings and we don't turn up with the information. Then they, based on whatever information they have in hand, they pass orders, right? Stating assessment orders under section 7A or 7Q, mentioning that this is the amount to be payable basis our assessment of the information collated by us during the time of inspection. Now this is the most dangerous thing to happen because there is a big picture which we are missing in across all these issues. Clearly the verification of claims of PF authorities, right? So I'll spend some time on it immediately after this slide because that is one of the most important things, and I feel somewhere as RPs we are facing difficulty in in ensuring a compliance of that same, right? So that is something which we have to work around. So anyways, I'll get to that, but then yeah. So as I was saying, the moratorium is staying a lot of issues against the company, even if they're pertaining to labor laws. But what continues regardless of moratorium is what interested me. Firstly, the relationship of employment, right? For those of us who are lawyers, for those of us who understand employment as a contract, we all know that it is a relationship. It is established as a relationship between the company and employer and an employee. So that's why they call it employer-employee relationship. And that relationship is established by way of a contract. It's an employment contract which will be entered into, which determines the rights, responsibilities, liabilities of the employee as well as the employer. Now here, as a corporate debtor, we are the employer, right? So the section 14 as a moratorium or nor any other section under the IBC do not comment on discharge of any contracts. All contracts will remain intact. As an RP, I have to decide what contracts, how to take it forward, and how to negotiate with the other party. All of these are certain business matters for which IBC is absolutely silent on, and IBC doesn't want to comment anything on that. It is left open for the COC and the RP to continue doing their business with the help of the employees of the company, right? So the CIRP in any stretch of imagination cannot be considered as the discharge of employees, unlike the liquidation process. right? So if you are aware, under section 35, where we are dealing with the liquidation, the section clearly mentions that an order of liquidation discharges the employees and workmen from their responsibilities as employees or workmen, unless and until if it is a company undergoing going concern and the liquidator chooses not to discharge them, right? And also in consultation with the committee and the NCLT, etc. So a CARP is not a discharge of relationship. So all the contracts will continue even after the RP will step into the management. So all the employee relationship will continue, their pay structure will continue as is, unless the RP is changing the pay structure, unless the RP is communicating anything contrary, and then that is a bilateral contract. Again, a new contract has been entered between the corporator and the employee. The existing employer-employee relationship established by way of the employment contract will be continuing in force, right? Will continue to be in force. Next, in terms of the current statutory obligation for the CARP period, again, this we have already explained, that whatever ESIC, EPF contributions to be made, gratuity accrual to be put in place, and any other compliances to be done under labor law legislations, all of those statutory obligations will continue, and the IRP, RP, or the liquidator cannot take the shelter of CIRP or the liquidation process under the IBC to exclude themselves from doing these compliances. These compliances are mandatory, and there is absolutely no exclusion or relaxation thereof. Next, in terms of the rights of the workmen to raise fresh industrial disputes, again, post CIRP, any fresh industrial disputes will might occur, and they'll always have the right to take it up against the company. And they can, in fact, again, of course, wherever there are any directors or personal guarantors, obviously they are not covered under the moratorium. So if the past disputes were, where were targeting the targeting the promoters individually in their individual capacity, then that will continue, and they will have to be answerable for the same. They cannot claim any protection under section 14. That obviously is clear, right? Now, in terms of one again, a practical insight from my side in my one of my matters is that, like, see, I was fortunate enough to be an RP of a company with some limited operations, and the cash flows are sufficient enough to meet the expenses. Particularly, apart from the finance cost, other expenses we were in a position to meet. We had enough credit from the operational creditors as well. Slowly and steadily, that position has come, and the concern was we were at the end of the financial year, and for the new financial year, the workmen, they had a union. Okay, the union, again, I don't know how many of you might be aware, or maybe many of you are already aware, that typically the labor unions in the country are, I'm not sure if I can say it on the call, but yeah, are kind of politically driven, right? Like, there are some political inclinations and support from local leaders meaning local political party association members, or political party leaders, or local members of legislative assembly or members of parliament, who may have some interest in protecting the rights of the union, right? So of course it's all in the best interest, but still there can be some political inclination, right? So similar thing happened where we were supposed to negotiate on increasing the wages of the workmen. I'm sorry. Just imagine what's happening. On one side, the companies under CIRP, we are looking at huge haircuts to the creditors. But on the other side, or rather on the flip side, we are supposed to give some increments considering the continuity of employees. Now look at increment. Let us look at increment from two angles. One, compliance. I'm sorry. So there is no law in the country which mandates you to provide increments, right? So therefore, as far as compliance is concerned, only complaints would be that my incremental, whatever increment I am providing to the wages or the salaries, they have to be in line with the wage structure in accordance with the code of wages which we have, the labor law, the labor code on the wages. So in accordance with that code, we need to ensure that the the wage structure or the the salary structure is in line with those regulations, with that code is what we need to ensure, right? So that is one major responsibility we 100% have from the compliance point of view. But more interestingly, the other point of view is that should the RP consider even such a request for increment when the RP is aware that the company is currently fighting this insolvency and trying to resolve? Because if I commit to provide that increment, that commitment will also be binding on the resolution applicant who will step into the shoes of the RP immediately after implementation of the plan. So at such juncture, when the implementation of the when the resolution applicant is coming into the control of the company, right? This increment or the incremented amounts of wages or salary might actually become a burden or might actually become a deterrent for the PRS to continue, because they may consider that already the costs are high, and then coupled with these increments, the fixed cost itself is becoming too high to continue running this company. That might also be a challenge. At the same time, think the other perspective is, if these increments are not given, there is a high chance that the RPs, there's a high chance that the employees may start looking out for other organizations, because see, it's already a company under in the soup. So few employees might understand that once the company is revived, they may have good importance, but few employees may have a impression that once the new management steps in, they may actually ask all of these guys to leave, right? So even these emotional decision making of the employees also plays a key role. That as a businessman, should I as an RP think as a businessman to retain the employees so that I can continue doing the business and making some money, or should I be looking at it from the strict perspective of the IBC, that a company itself is undergoing insolvency? There should not be a question of increment. What should be the thought process, right? So that is where I think, again, there is no hard rule. Either of the position might be in favor of the RP, as long as the RP can establish that it is a well thought after, or there has been good enough consultation with the creditors, with the relevant experts in the field before such a decision has been taken, either to provide for increments or to discontinue the increments. If you're providing for the increments, obviously, nothing said otherwise, even as per the recent CARP regulations, you are supposed to get a prior approval from the creditors for such kind of costs, right? So therefore, such compliances under the IBC also has to be ensured by the RP, right? So to summarize, increments are quite tricky during CARP, because if you don't give the increments, there is a high chance that the employees start leaving the organization. And if you give the increment, there is a high chance that there is liquidity crunch. There might be a liquidity crunch coming sooner into the company. And I'm just assuming, if at all the company is not in a position to be handled, in that way, then obviously the money cannot be coming again back. So therefore, the increment per se will play a crucial role in ensuring that the employees are continuing in the company, and employees are making sure that the employees are not resigning or joining other organizations. So that is one side of the story. The other side of the story for increment is that even after the increment, the employees may just consider it as a minor increment, not sufficient enough, and then start looking out for other opportunities. So therefore, a decision on increments is actually vital, and it has some repercussion on how the operations will be taken up. And apart from this, as I was explaining, in one of my matters where I was negotiating with the labor union, the labor union has suddenly brought in a political face who was who has taken the discussion on an entirely different level, right? Because they obviously have certain inclination to support the workmen, but from our point of view, we were looking like, see, as an RP, it's a tough decision, because if the COC rejects, that nothing saying I'm not going to give a single rupee as an increment, then as an RP, I don't have a discretion, even though I think the cash flows are sufficient, even though I think this workforce is needed, I can't take a decision against the wish of the COC, particularly when it talks about the costs for running the company as a going concern. Because my contrary decision will 100% have a repercussion on the cost, which ultimately has to be ratified or approved by the COC. So a thing which cannot be done directly should not be done indirectly, right? So therefore, I cannot on one side go to COC, take an approval for the cost incurred for increment, which might be rejected by the COC, and on parallelly allow such increments to be taken up on record. Right. So since it is subject to the approval of the COC, I should ensure that I am giving adequate time for the COC to take a decision, and then only to allow the increment to be affected to the workmen. So in my case, there were multiple negotiations which have happened with the union alongside the political member, and then only we have concluded and closed on the increment proposal, then placed it before the COC for its perusal, and then ultimately after the approval we have started paying them along with arrears. Right. So that's about it in terms of how increment plays a critical role even during CARP. Though there is moratorium, it might become tricky because we cannot expect the employees to understand. I mean, at times it becomes very difficult for the employees to understand what we are trying to comprehend, because for them inflation matters, increment matters, right? So obviously as RPs it will somehow become our responsibility to also see to it that their interests are also being protected, because they are also one of the stakeholders in the company, right? So that's all about this. I'm just moving on to the next slide. Yeah, I'm just okay. Now, as we move forward, let's just understand a couple of again basic issues which we have already again kind of directly discussed, but uh, wanted to keep it as a flow. Like, like if the CD was ever managed as a going concern, if the answer is yes, then the second question: did the workman or employee actually work during the CARP? Right. So, did we manage as RPs? Did we manage this company as a going concern? And if we managed it, did this particular employee or workman actually work during the process? Then their salaries will be considered as CARP cost and will be paid as in top priority under section 53(1)(a), as they come under the definition of CARP cost. So this point is absolutely clear. All the wages payable to the workmen, salaries payable to the employees shall be considered as CARP cost, as long as they have continued to provide their services during the CARP. Of course, it remains, it will be, I mean, it is different when, when we actually make the, I mean, if at all we terminate the services, what happens is a different scenario altogether. But if we're continuing the services, then this is how we'll have to end up making the priority payment to them, right? And if either of it is no, right, then in such cases, typically their dues will be prior to the CARP. They have no other choice but to file a claim, and that claim will be filed along with their supporting documents, and the same will be considered by the company. So this is in terms of understanding the wages or the workman dues. Now let's look into certain to-dos which we need to do as RPs during this process, right? During the CARP process, and let's also understand what kind of steps has to be done by us, right? So first and foremost, the workforce audit, right? So this is just a terminology which I tried to bring in. There is nothing, there is no legal terminology as such for the workforce audit. The workforce audit is nothing but Typically when you have a manufacturing unit which is being run parallelly, as RPs, we need to go there and understand firstly as to how the attendance is being recorded. Is it digitalized? Is it is there a biometric which is installed in each of the manufacturing facilities that the employees punch in before they enter into a respective department? And is there interdepartmental biometric made available so that the employer knows the movement of employees from one department to the other? Or is there what kind of attendance mechanism is in place to record the attendance is something which has to be looked into. And apart from that, the muster roles, right? So how are you maintaining the roles? Like if there are contract workmen who are being put in place, how is it that their attendance being recorded or registered, right? And what kind of inspections or court cases are pending against the company, and what are the logins, the PF logins, the ESIC logins, or even including the codes, PF code and ESIC code based on the place where they have the employees registered. All these kind of issues, including even the union agreements in place, what unions we have in place, whether they are valid, what is the registration certificate of the union, interactions with the union leaders to make sure that they are on our side. All of this will form part of our workforce audit. So if we are appointed as RPs of a company which has operations, we need to ensure that this workforce audit is being done parallel to what we do under IBC. Obviously, under IBC, we become extremely busy in getting into some mandatory things like publishing public announcement. Then claims start coming. Then we start reviewing the claims, verifying the claims, conducting COC meetings. Doing everything what is needed under the IBC, like valuation, Form G publications, interacting with the PRAs, giving them information, etc., etc. Now, this is one part of our role, which is nothing but conducting the CARP process. Now, as per the IBC, there are two roles given to the RP. One is to conduct the corporate insolvency resolution process, and the other is to manage the operations of the corporate debtor as a going concern. Now, what all we are discussing today is the second part of it, which is to manage the operations of the corporate debtor as a going concern. So, workforce audit has to commence on day one, and of course, it will continue basis the size and scale of operations of the corporate debtor. Second is to decide the going concern posture. Now, we need to understand that we need we need these employees, we need this workmen or the labor force to continue because they are essential for affecting the operations of the company, right? So this rationale is extremely important to be decided upfront so that the RP can justify before the COC on the labor or cost or the wage cost that why they have been retained. Now, this may not be for individual. Let's say there's a company with 800 employees. Now, obviously, as an RP, we don't see each profile to see whether they are required or not. But overall, what is the cost, wage cost, the labor cost against the revenue? If it is a very industrially acceptable percentage, then the RP need not raise any red flags to the COC. That obviously will go in line with whatever are the employments already in place, and we will continue to this as a going concern by retaining the entire staff. But let's say there is a unit and there are the operations are shut 3-4 years back, but the company still continues to the employees still continue to come. There are let's say 10-15 or very small strength of 10-15 employees who are still continuing regularly coming to office, just because their employment services are not terminated. Now, at this stage, the RP can take a call that was this unit is not a going concern and we don't need these resources, so we can immediately terminate them. Of course, termination comes with some obligations. That is again a very interesting discussion altogether. But a decision on the going concern position of the company is also an important thing which the RP has to take care of during the CARP. Third, on the payroll. Now, see, payroll, why it is important is because payroll is directly related to the CARP cost. Now, if you don't have a proper payroll in place, in such case, there's always a chance of incremental costs being reported by placing false records in place, by forging or manipulating the employee attendance records, etc. Right? So that's something which is important. We need to ensure that that is being taken due care of. And under payroll, multiple things come in. One is making payment of salaries. Second is deducting the PF and ESIC portions and depositing the same with the respective authorities. Right. So all these issues also will be captured. Next is in terms of verifying the workforce claims. Obviously, we will keep receiving claims from the workmen or employees, and we need to, from time to time, verify such claims by matching it with the records of the company, and then ultimately to determine the claims and upload this list of employees or workmen on the website of the company. Now, just one practical insight in this is that, like as I said recently, I'm closely associated with the company as a going concern, assisting the RP. Now, over there were multiple employees in the marketing force. Now, so this is an interesting thing. Actually, when I was interacting with those employees in the marketing team, what I realized is this marketing team is not sitting in an office or not doing a desk job. They are running from pillar to post to sell the product of the company, right? So if it's a pharma company, they will go to the doctors, to the clinics. If it is a product, right, like some manufactured product, then they will be heading to the respective potential customers who might be who might be interested to get those products, right? So sales team is typically on the go. They are always traveling. They would, even though we are paying them salaries, that obviously won't be sufficient for them to take care of their travel. So we'll have to parallelly incur the expenses for their travel. So for which we need to compensate them with some additional benefit, right? So these kind of issues do come up when you have a marketing team in force. So such marketing team who or such employees will be curious to know what's happening with their claims, right? So recently because of the advent of AI, if once they start typing the name of the company and then say employee claims or whatever, the claims filed with the IBBI get circulated. Like for instance, in this case where I was handling, earlier when we constituted the COC, we just received 4 claims from the employees. So we uploaded it with the IBBI. Subsequently, we received almost another 90, 98 or some odd number of claims has already come. In the second round, when we received only 60 claims from employees, we uploaded all those claim details on the IBBI. And in the third round, we had 140 claims or something. I'm sorry, 110 claims or something. All of that also has been uploaded on the IBBI portal. But unfortunately, only the first copy of results has been displayed whenever they were doing a Google search, and then they started becoming suspicious as to why their claims are, even though the claims are acknowledged on the email, why is it that they have not been submitted to the IBBI? It was only then I understood there is a disconnect, and employees are also always being curious to know what's happening with their claim amounts. So therefore, we directed all of them, written emails to them saying that whenever there is any update in the claim, it will be made available on the website of the company. So we also started uploading that on the website of the company, so that they need not do this Google search and all. They can simply go to the website of the company and access the list of creditors available on the website of the company. So that was the thought process with which we are trying to support them, just to understand what's happening with their claims. But there is another important issue over here. Generally, this process of submission of claims is followed by procedure of invitation of resolution plans, and then ultimately the resolution applicant will propose what has to be paid to the employees, right? So it's not always the case that employees receive their full dues, and we as RPs are always aware of it. But unfortunately, what happens is, as an employee, right, after they submit their claim, they form an impression that the claim is submitted in order for us to release the payments, right? But we all know, right? We all know that the claim is submitted for a different purpose. The purpose is for us to collect the claims and give a position of what is the claims, to give a position on what is the claims to the respective resolution applicant so that they can come forward and submit their plan. So that is the whole idea of providing for claims. But then for employees, at times it becomes difficult for them to understand that just because they submit their claim doesn't guarantee them for a full-time payment. So again, that becomes one additional responsibility on the RP to adequately communicate this as a fact to all the employees that you are just submitting your claim. It's not going to guarantee you any immediate payment. So our email communications should provide such clarification so that there is no confusion amongst the employees in terms of what's the consequence after they submit their claims, right? So it might not be a legal responsibility, but morally we need to give such kind of communication to them. Then comes another interesting point under workforce claims, that is with respect to PF dues. Now it may so happen that, just imagine that for 2 years prior to the CIRP, let's say the company has not made a single rupee of payment to the employees. Employees have still continued working, whatever be the reason. Then the employees started accumulating certain PF dues, right? Now we have studied that workman dues also include all PF dues, etc., etc. Now it may so happen that the workman will come forward and submit their claim along with the PF. Right? Let's say 20,000 is their salary, then there is a proportion of PF to be deducted on the basic and DA. That PF to be deducted from the employee's share and also employer's contribution. Together would be the total PF entitlement to the employee. Now that PF entitlement, as per the CTC, they will straightforward claim as part of their workman claim or employee claim. Now parallelly, the PF authority has also filed a claim. Now PF authority obviously is filing a claim for the PF contribution both of employee as well as employer. So typically what's happening is the employee share as well as the employer share of PF, that is the nothing but the PF dues, have been claimed by both the PF authority as well as by the employees. Now what should we do in such a situation? Right? I repeat the question. The claim with respect to provident fund dues have been submitted or has been submitted by the employees as well as by the PF authority. So technically, for one claim we received, or rather one legitimate amount of dues, we received two claims. One from the respect to employee and one from the provident fund, which is representing the collective body of employees. So whose claim should be considered? I hope the answer is clear for all of you. The answer is obviously the claim of the PF authority. The reason being, this PF amount is ideally to be parked with the PF authority, and there is a process for the employees to withdraw such PF dues. So therefore, if at all the employees come forward and submit their dues along with the PF, it is not meant to be considered unless PF authority fails to submit a claim. But if PF authority has also submitted its claim, then we have to mandatorily consider the claim submitted by the PF authority, and we should not admit the claim submitted by the employees towards their PF dues because the PF authority has already claimed for it. So there is definitely a chance for double claiming of double claiming of claim amount. So we need to be aware of the same only with respect to the PF dues, right? As we move forward, the IM, right, disclosure in the information memorandum. Now, in the information memorandum, we should adequately disclose whatever are the dues, right? So that is extremely important for us to make sure that the information memorandum has adequate level of information in terms of the pending employee dues. Right? So that's about it in terms of the IM. And finally, when it comes to the stage of resolution plan and the complaints check under section 30 subsection 2, we need to see to it that the resolution applicant has not submitted a plan in violation of the provisions of the IBC and the judicial precedences for payment of PF or gratuity in full. So the resolution professional should ensure that the resolution applicants are proposing for full payments of PF dues and gratuity to all the employees. So that has to be taken care of by the resolution professional. And also, of course, all the CARP costs, right? If there are any dues payable during the CARP, that has to be paid in full, right? So even that has to be adequately ensured. So these are all the major compliance checkpoints which we have in the process from end to end. And before we move forward, if we can take a quick 5 minute break, that will help me just to recoup for the second part or second leg of this session. So we'll just take a very quick 5 minute break and rejoin on the rest of the session. Right. Thank you. We'll now continue with the next leg of our session. First, in terms of workforce claims, right? So, what all we do, we look into in order to verify and determine the claims of the workmen. First, of course, the format in which they can submit, Form D, and if they want to submit it collectively through an authorized representative, then it will be in Form E. The authorized representative is submitted in Form E. Then for the proof, we will have to look into the appointment letters, full and final settlement letters. If the employees have already resigned, their PF statements filed with the PF authorities, which will also be a proof of payment of salaries, any awards from tribunal, any industrial dispute tribunals or other employee forums where orders have been provided for. So all of that will come under the ambit of the proofs which we need to submit, right? I mean, which we can rely on. Then moving forward in terms of the estimation, again, wherever we don't have a precise amounts, we can try to make a best estimate basis the balance sheet figures as well, right? Next, in terms of contingent or disputed claims, if at all they are pending, then obviously we have no option but to admit it at notional values, or we have to outrightly not admit it, which might invite a challenge under Section 60, subsection 5. And of course, we know that there is no COC seat for them. As I said, it's full. It's only full. I mean, only financial creditors are there in COC, so that is also not possible. Um, yeah. So this is one part of it, but again, one thing which we have seen from various orders passed in NCLAT and NCLT is that even though the employees don't come forward, we should also, like as RP, we should put in some efforts to see to it that all the dues of employees are adequately collated, so that if needed, we reach out to the employees to see to it that they submit their claims, so that it is in the best interest of the employees that such things has to be proactively done by the RP, and the same should also be adequately recorded in the IM, so that the resolution applicants may provide for certain contingency fund if at all such employees come forward at a later point in time, right? So the idea is, though legally we need not do all that, but they can still come forward and support on that. Now, as we move forward, in terms of the dues which are outside the process, again, these are certain rulings from the Honorable NCLT and NCLAT and Supreme Court. Most famous ruling is in terms of the jet aircraft, so the Jet Airways case, where the Welfare Association of the employees have filed an appeal before the Supreme Court and NCLAT for ensuring that their PF and gratuity dues shall be paid in full, and they were able to get a favorable order. And subsequent to that, a lot of things have changed. In fact, Jet Airways is currently under liquidation, so it's not that the employees have recovered anything, unfortunately. But that case had set a precedent whereby subsequently in all matters under CIRP, all resolution applicants are proposing full payments to the employees as well as the workmen, right? So that's one interesting amendment. I mean, that's one interesting learning from that case. So that's something which we need to. I mean, that's something which is being complied by all the resolution applicants subsequent to the process, right? Yeah. Now, the Section 53, what we were referring to in terms of the waterfall mechanism, or rather the order of priority. Again, we have already seen this part, right? Kind of had a brief understanding that Section 53 1A deals with CRP costs and liquidation costs in full. Then followed by B, workmen dues. C, wages and workmen dues pari passu with secured creditors who relinquish security. C, followed by wages and unpaid dues of other employees for 12 months. And then we have unsecured FCs, government dues, and residual secured creditor dues, and then remaining debts, right? and then preference shares, and then equity shares. I mean, equal shareholder. So this is the order of priority provided under the code. But then the one in orange, if you can see on the top of the screen, is the waterfall mechanism whereby the workforce, that is the dues payable to the employees, will be standing outside the estate, right? So this particular Yeah. So this particular payment with respect to PF dues, pension funds, and gratuity fund dues will be outside the estate, and therefore the same cannot be made available for the other creditors for the matter of distribution. Just wanted to pictorially depict the same so that it is easier for our understanding, right? Uh, yeah. As we moved on in terms of uh, closures, right? So this is an interesting thing. We'll have to spend some time on understanding this. Now, can RP downsize the company's operations, or maybe even including company's employees? Can there be a possibility of a layoff or a retrenchment? Now, this is an interesting thing because it also has a financial implication. It's not that I just wind off and then I don't have any issue. I'll not get any financial issue on this. So there's definitely a financial implication on what things we do. So can the RP downsize is an interesting question. Let us try to analyze it. Now, during the CIRP, now what happens during the CIRP? Now, we know that RP is the one in charge to operate the company as a going concern, and the business decision of rationalizing the workforce 100% comes within the ambit of managing the operations as a going concern. So just like how a managing director or a CEO or the manager of any company, or under IBC gets a right to decide whether or not to terminate someone on behalf of the company. So the similar rights can 100% be applicable for the RP as well, but subject to condition that the labor law still continues to apply. Right? The labor law should not be considered as suspended. That will still be there. If you are retrenching somebody outright, then you will have to end up paying retrenchment compensation. You'll have to pay notice period, whatever is the amount. And if the thresholds apply where they have service for more than 5 years, even the gratuity becomes applicable, right? So therefore, as I said, there are certain financial implications, but at times it may so happen that the financial implications of termination are much lesser than the financial implication of continuing the workforce. Then that's a tough decision which the RP in consultation with the COC shall take. Now, going by the position on transfer of undertaking, see the section again is a old reference, my bad. The new section under the Industrial Relations Code, if my memory goes right, should be section 73, read with section 78. But anyways, I'll rectify that when I circulate this PPT. So whenever there is a business transfer, typically when there is a transfer of undertaking, then if you are terminating the employees, let us say a resolution applicant comes in, and as part of the plan the undertaking is transferred to some other entity, right? Because we can 100% do that. We can do a demerger, or we can simply say that the workmen shall now be continuing to be run, the business will be transferred to so and so company. We can provide for all of that as part of our plan, right? So if something of that sort is provided for, then it will 100% be amounting to a transfer of undertaking. And all that which applies for a transfer of undertaking in a normal course of business will also apply in the case of a resolution plan. Because if you remember section 30, if you recollect section 30 subsection 2 clause E, it clearly says that the resolution professional shall examine whether the resolution plan is in compliance with all the laws applicable to that particular company, right? So if at all the plan provides for any transfer of undertaking, then even that will become applicable, right? So therefore, if the workman is entitled for a notice and compensation as if they are retrenched, then the same shall also apply if the plan provides for either a slump sale or a business sale of that particular undertaking. Now, in not just the plan, let us say this is being transferred as part of the CIRP, right? Let's say there is a slump sale of the factory along with its employees. Now, in such a situation, that would amount to a transfer of undertaking, and the one who is purchasing it should also keep in mind that these compensations have to be duly addressed, right? So that's something which needs to be taken care of. And suppose the tenure, the services of the employees are continued in no terms, in no less favorable or terms than that have been provided prior to the transfer, then the transferee will assume the continued liability. Then these financial application, implications will not come. So transfer of undertaking is an interesting thing, because typically in a company where there's a going concern, whenever a resolution applicant steps in, how the resolution applicant considers the or treats the employees will become an interesting area of concern for resolution professionals. And of course, see, technically that is not responsibility of the resolution professional, because it's a post implementation complaints. So it is for the resolution applicants to take up. So therefore, I'm not spending more time on this, but nevertheless, it's an interesting area of to look into, because resolution professionals, though we are confined to CARP, it's highly likely that resolution applicants may engage us to advise them on implementing a plan, and that's where these kind of issues or our expertise in handling such issues can come handy. Right now, in terms, but if you see a liquidation process, now in a liquidation process, if at all we are terminating, I mean, there is a discharge of workmen, right? So their workmen dues are typically crystallized as a Section 53 waterfall, right? So now this waterfall or this compensation payable to the workmen will still apply, irrespective, or irrespective of whether it is under IBC or not. In a sense, just because we have liquidated them as part of IBC doesn't mean that they cannot claim anything during the process. And obvious that whatever claims are pending to the workmen, they will come forward and they'll have to mandatorily claim it before the liquidator, right? And yeah, so with in terms of just a compliance update for threshold, as per the industrial relations code, now if we have to mandatorily, if we want to retrench more than 300 workers, then we have to mandatorily take a prior permission from the labor department. Now this is something which is important. Now let us read this point in line with the previous point, which is closure in liquidation. Now in liquidation, as I said, as per the operation of law, all the workmen are deemed to have been discharged, right? That is in accordance, this is as per the operation of law. Now, if in any other case, if I am retrenching all the workmen, earlier it was 100, now if it is in excess of 300 workers, if I am retrenching them, then I'll have to mandatorily apply for a prior permission before the labor law department for allowing me to lay off them or retrench them, or even to close the entire unit. I'll have to take a prior permission from the labor department. Now, see where this is all stemming from. So, this is stemming from the fact that labor law legislations have evolved after a lot of revolution, right? So, revolution for their rights, revolution for their safety, revolution for ensuring job security, right? So, why do we have Payment of Wages Act? Why is there a minimum wages prescribed? Why do we have equal remuneration? Like, if there's a men or women, there should not be a distinction. The payment has to be based on work, not based on gender. Now, why did we get all this? Is because there were some certain discriminations done prior. So therefore, to ensure and protect the interests of the employees, these legislations have come. Now, one cannot argue that these legislations are inconsistent with that of the IBC. These legislations are very much consistent, and they will co-live with the IBC, and they should be harmoniously interpreted. So if during the CIRP, the RP thinks the company has 1,000 workmen, while the operations have come down to 10% of the capacity, the RP wants to take a call to shut down, or rather to lay off. See, if we are laying off, what is the difference between laying off and retrenching? Is that in layoff, I will still have to pay them at least 50% of their pay, subject to them coming to the factory and ensuring their attendance throughout, right? But if it is retrenchment, I am completely taking them away from the company, right? So for neither of the situations, or if I'm closing down certain units where I don't, the company has no operations, I'm just closing down the entire operations and asking them to, retrenching entire workforce in that particular unit. In such cases, if the number of workmen who are getting impacted is more than 300, then I'll have to mandatorily seek for a prior permission from the local labor law department, which is nothing but a department functioning under the Ministry of Law and Ministry of Labor and Employment. So under that ministry, this department of the Labor Department will be concerned. So we'll have to make an application for prior permission to do this by giving a detailed explanation with reasons in writing as to why I am doing this. Then the department will do certain hearing as to the reason why it has to be done. If required, they will even appoint a committee to look into this, which will then do an inspection and give a ground report to the department as to whether that request is warranted, and then that prior permission will be granted. But generally, that kind of permissions are given because there are two ways of looking at it. One, protecting the employee's interest. Second, protecting the business, which is, or the factory or the interest of that particular business, which is ultimately going to feed the employment in the near future. So the Department of Labor, though, is concerned with the labor rights, at the same time it cannot override its role to say that no, you cannot terminate. If the reasoning is just justified, if the company actually is not doing any production, not making any money, 100% the company can avail for the prior permission. And in the past, many companies have also received such prior permissions for closure of the units, right? So this is something which, if the RP is looking for such kind of layoffs or retrenchments or downsizing the workmen, these things will apply. But if it is only for employees, the white collared employees who are working in, generally the such huge strength you don't find in companies under insolvency. But even if you do find, and if you want to terminate all of them at once, in such cases, this prior of permission and all will not apply because they don't come under the definition of workmen. So therefore, what all applies would be whatever is the contractual obligation we have with that respect to employee, like the notice period payment or whatsoever, that will definitely be applicable, right? So retrenching employees during the CARP will tantamount to certain compliances, and the RP cannot plead for any relaxation from such compliances, right? And even if you look at it from a practical point of view, it is definitely likely that RP may have to end up taking such tough calls. So my only suggestion for such RPs would be, make sure either you are completely aware of what the position of law is, or engage somebody who can assist you. There are various labor law consultants who give opinions, written opinions, or also they may even take up the assignments for licensing with the respect to labor law department. So such things we should encourage, we should convince the COC to allow a certain cost for bringing in a labor law consultant in place, so that these kind of sensitive issues are handled strictly in accordance with the law. So that the chances are highly likely that such actions of the RP will be challenged. Now, irrespective of the intention of the RP, the challenge would be more on the conduct of the RP, right? Now, that conduct will 100% give way to that conduct will 100% give way for some scope for some applicant to go ahead and file any complaint. So that is something which is scary, and the RP should ensure such stage is not arrived at, and the RP should ensure that all the compliances necessary to downsize the company's employees or workmen, as the case may be, all the required compliances and the cost analysis, right? So cost benefit analysis also has to be placed before the COC. All of it has to be clearly recorded, uh, and all of this has to be clearly recorded, and the same shall be made kept in writing clearly in the minutes of the meeting of the COC. That is how we can protect the interest of the RP, coupled with any legal opinion from a labor law consultant or a law firm will also help the RP in backing up their decisions. And assuming all of this will be a point of concern or contention before the before any forum, even including NCLT or any other forum, right? So that's something which we need to obviously avoid, right? We can't afford for litigation against the RP. I mean, particularly for things which we are not concerned about. Right. Let me move on to the next slide now. As we move forward, let's look at what happens to employees as a matter of going concern. Like particularly one in the case of resolution plan, second in the case of liquidation. In the past, going concern sale. So today we don't have a going concern sale anymore. Just discussing what was the situation in the past, because there might be cases which are still pending and are continued. Such things also might be there. And if it is in this case of scheme under section 230. In all these three scenarios, let us understand what kind of outcomes the employees might and might face, and what kind of compliances are also concerned with that. Now, as part of resolution plan, typically, if you see the entire IBC and the regulations, there is nothing mentioned in terms of what happens to an employee upon approval of a plan. The reason is simple. The reason is that what is the treatment provided to the employees should be recorded in the resolution plan. It is not the duty, or it has nothing to do with the IBBI or the ministry to come up with certain mandatory thing on ensuring what has to be protected within employees, right? If they do so, then it would 100% become a social legislation than a commercial legislation. See, if this was handled by a Ministry of Labor Law, Ministry of Labor and Employment, they would have 100% mentioned that this has to be, the interests of the employees have to be protected. They'll have to mandatorily be continued in employment or something like that, because welfare of employees is what is their core idea. That's the preamble of their all the legislations. But for IBC, that's not the case. It is more on, it's obviously it's a commercial legislation. It is under the Ministry of Corporate Affairs, and they have got more, they are meant to make sure that the code works for the market to take up these kind of companies and acquire such companies and start running those dead units. So therefore, any such obligation to mandatorily continue or provide an automatic transfer of employees is not part of the plan. There is no such thing. It is a resolution plan which will govern whether you are continuing the employees, absorbing them, what happens to the past service, etc. All of it will be part of your resolution plan. Now, we are all aware of this clean slate theory, which was initially laid down in all the major rulings of the Supreme Court, and then strongly reaffirmed in the Ghanshyam Mishra case, which we usually refer for whenever we are talking about past liabilities not to be accrued on the company post approval. So it is clear that if a claim is not filed during the process, then the claim is extinguished. So if the employees don't file their claim in time, they will 100% lose their right. So that would be the outcome. They will not get any, they cannot, as a matter of right, claim anything from the new management. And typically what we have observed was, if it is a company with no employees, obviously there is no concern. But if it is a going concern case, then the plans provide for certain compensation to employees. I mean, obviously the plans will give some liberty to the resolution applicant to decide on whom to terminate and whom not to terminate, but which would 100% be subject to the applicable laws. So a resolution plan which states that without any compensation, the resolution applicant shall have the right to terminate all the employees. That kind of clauses cannot survive. Whatever are the obligations, whatever are the consequences of termination of employees, the same shall apply even if it is by way of an implementation of a resolution plan, because the law doesn't provide for any such relief as such. So that is in terms of the resolution plan. Similar thing applies even for a going concern sale under liquidation. Like just to give you a recap, Regulation 32E and F were earlier part of this liquidation regulations, liquidation process regulations, but today both of these sub-regulations have been omitted from the regulation. So therefore, there is no going concern sale or sale of business as a going concern. Only sale possible is a slump sale. So, but for those cases where this is applicable, it is, this particular sale, if at all at the time you are doing a going concern of the entire business or the say CD, if you have identified, because the regulations earlier required for mapping of assets and liabilities, if the employees were also included as part of the same, then there is definitely a transfer of undertaking, right? So if there is a transfer of undertaking, then the terms of sale will dictate what happens to the employee's dues. So obviously, any dues prior to the insolvency commencement date shall be considered as claims. Any dues after insolvency commencement date shall be considered as CARP cost or liquidation cost, as the case may be, which shall be borne in full by the corporate debtor. That is, RP or the liquidator shall ensure that the entire money has been paid. So for all past dues, the the employee or workman should have filed a claim. So for all past dues, you cannot bind the new bidder, right? So that will still be distributed in against the estate of the company under Section 53. But for uh, uh, for all new, for dues which are accruing subsequent to the transfer, the buyer will become responsible, right? Now, this treatment of workforce we need to clearly identify in the process memorandum as to how that will apply and how the employees are also being transferred. So upon transfer, will that amount to a retrenchment? Yes, it will 100% amount to a retrenchment. Then how are we addressing it? How we are addressing it is that, because if at all it's an entire going concern sale, there is no concern, because the company, ideally the bidder will continue as a shareholder of the corporate debtor. But if it is a business being sold as a going concern, in such a case, the undertaking is 100% being shifted. So it will be sold to a new undertaking or a new company. So in such a case, it is clear cut case of a retrenchment, and the corporate debtor will have to make the retrenchment payment or notice payment or any other statutory obligations. However, if the buyer is bound as part of the terms of sale, they are bound to absorb these employees and continue making them payments in no less favorable terms than what were paid by the CD. And if the buyer is giving that undertaking and continuing them, even their continuity of service, including that of gratuity, that is the continuity of service from a prior period, if all of that is being ensured by the new bidder, and which is being stipulated by the liquidator as part of the terms of the sale, only then there is no case of retrenchment. That is, there is a clear-cut exemption provided in the Industrial Relations Code, right? So as liquidators, when we are doing, even today, if you are doing a slump sale along with employees, if that is being transferred, if the employees are also being transferred as part of your slump sale, if something of that sort is being explored, then we should also take care of this compliance under the labor law. Otherwise, that will be an additional burden, which is a CRP cost, or which is a liquidation cost, which we cannot foresee. Which we cannot ignore, right? So we need to make sure that the terms and conditions of the sale are adequately drafted. Otherwise, there is a severe concern which we may have to face, right? And moving forward, in terms of any scheme being proposed under Section 230 in liquidation, now, as we know, there is a window of 90 days still prevailing for considering schemes under liquidation. And there is, and like though there is a precedent earlier, but now the law itself very clearly states that the liquidator must explore the possibility of a compromise. Even during the CIRP, the COC can decide the can push the RP as per regulation 39C, that 39A or 30, I think 39C CA. There's the COC can resolve that the RP may explore the possibility of submission of a compromise or arrangement, so that that time period when the application is pending before the before the NCLT for disposal, the RP can use that time for exploring the possibility of a compromise or a compromise, and the same may be presented immediately upon liquidation. The same may be presented before the NCLT for its formal consideration. Right, so that is something which can be done. So if at all through a scheme this company is being acquired or maybe taken back, then the employee there has to be a clause on how the employees are being considered, right? So and a clause on how the employees are being considered to be continued has to mandatorily come as part of the scheme, and that also has to be in compliance with the law. Right? Just because it is a scheme proposed under Companies Act Section 230 read with the IBC doesn't give any additional reliefs. In as long as as far as the employee claims are concerned, if you are retrenching the employees as part of your scheme, then the entire retrenchment benefit, everything as is applicable under the Industrial Relations Code shall apply. If you are continuing the services, then of course, as per the proviso provided in that regulations, there would not be anything which will have an impact on you. So this is in terms of the outcomes of going concern. Now, this is one thing I think I missed on the slide is in terms of a resolution plan. Now, majority of us are aware that under the CIRP regulations, there is a requirement, I mean, there is a flexibility to invite resolution plans uh, on like based also by way of inviting resolution plans only for select assets, right? What I mean is that the COC and the RP can divide the company into multiple layers like asset 1, asset 2, asset 3, asset 4. And for each asset also you can separately invite resolution plans. Like let's say company has got three different businesses, has nothing to do with each other, but are being under the same books. Since you are not able to find an applicant who can meet the requirements of all the three, you have wanted to invite plans for these businesses separately. Now, is it possible? Yes, it is possible by way of inviting plans differently for different assets. So to ensure that it is being taken care of, that these units are being separately dealt with, one can argue that these things can be separately invited for, that is a request for plan resolution plan can be separately invited for these different assets, and for in each of this case the question on employee continuity shall be adequately addressed, right? So that's something which I thought can be an interesting add-on for us during that discussion. Now let's look into the recent developments in terms of the four labor codes which are in force from November 2025. Now, the term workman is now being made gender neutral by mentioning it as worker, right? And the Industrial Relationships Code, uh, read with the General Process Act, also clearly map our claim classifications. Obviously, there is no difficulty in that. Now, thresholds recalibrated, as I was explaining, the prior permission will now be sought only if there is retrenchment, layoff, or closure of more than 300 plus workers. And standing orders as is mandatory when you have more than 300 plus workers. And this would obviously be a compliance step for us to know. Then fixed term employment, we like your gratuity estimation will now have some kind of a difference in terms of recording in the books, considering the prorated gratuity payment starting from year one, right? So earlier, obviously, as we are aware, we need to like if at all there is a fixed, like let's say you have a fixed term employment with a particular employee, then in such a cases you need to ensure that right from year one the pro rata gratuity payments are starting to be paid to such employees, right? Next, now we have a uniform definition of wages. Earlier, for each legislation, we had different definition of wage based on which the pay slips are being designed by companies differently in different cases, right? But now they made it clear that it has to be uniform. Your basic has to be 50%. Right? There is a 50% floor on your basic plus DA component, right? Thereby, the PF or gratuity computations definitely will undergo a change when as and when they are being computed. So the RPs should ensure that during the CARP or liquidation, whenever there's a going concern, the pay structure is in line with this labor laws. Then we, of course, negotiating with the union council, we need at least 51. Union should have 51% membership. It obviously will be as per the law that these negotiations take place between the RP settle. I mean, the proposed resolution plan settlements of workmen during CARP. However, this has to be at the level of compliances stipulated for the union labor. Then any the other part is in terms of transition. Like obviously, we are aware that upon the resolution professionals stepping into shoes, there are certain issues in terms of the transition because the control is now shifted from the suspended board to that of the RP, and subsequently that will now be shifted to the new management. So the certain legacy issues and defaults should ideally come with to the notice of the RP. The RP has to look into it and guide the respective departments for submitting their respective claims. So these are just generic points, but the more important ones are what we have discussed in the above, in terms of how the wages definition has been made uniform across, and in fact, even the certain labor law reform which have come into force for ensuring better safety and security of women at workforce, and at times in few fact, now even the second shift for women employees is also being facilitated as part of these regulations. Now that will also come out with a lot of more security concerns and responsibility which the RP has to make sure that if such kind of work facilities are being provided for in accordance with the regulations, then adequate measures are put in place to ensure no threat is being posed to any employee, particularly women employees. That also has to be ensured by the RP. Now, in terms of certain landmark rulings, again, we have already seen majority of like cover majority of this. Just the takeaways you can see in terms of how the interpretations of sections have been provided for. So this, I think, kind of self-explanatory. Nothing much to dwell upon. But overall, we have tried to capture it in full. Again, coming back, the major law which governs the dues of PF and gratuity again remains that of the Jet Airways ruling. That is the prime principal ruling which has to be run through by every RP to make sure that none of their cases we have any non-compliance of the precedent set in this particular ruling, right? Now, some do's and don'ts, most important in terms of compliances. Let us quickly have a look, right? Firstly, in terms of depositing the PF funds and ESIC on every month, this is non-negotiable. Please note that like COC cannot have a right to reject such CARP costs, even though the law mandates for prior approval of COC towards incurring the CARP costs. You need to, remember one thing. If you're continuing the employees, then you have to end up making this EPF and ESA payments. So the COC and the RP should ensure that this is not negotiable. This has to be paid because this also comes under the role of the IRP and RP to ensure compliance of every law, right? So depositing both the employee share as well as the employer's contribution with respect to PF and ESA authorities is mandatory, right? Next, in line with the going concern decision, whether since you are continuing the company as a going concern, right? So who all are working, what is the employee, who are all the employee strength, etc. That has to be clearly documented, and we need to document the pending PF dues, pension dues, gratuity dues, etc. And we have to disclose it adequately in the information memorandum, and ensure that the RA is disclosing it as well in the resolution plan, and proposing it as part of the distributions as well. Now, at the verification stage itself, we need to ensure that we are distinguishing between the workman and the employee. That is also extremely important. And post November 25, since I said, and also post May 26, since all the rules are in place, we should 100% do a labor law compliance audit to see whether all the new labor law requirements are being met or not. Obviously, majority of them have been adopted from the old laws only, but here and there few additional changes which have been made has to be taken care of, right? So these are certain do's. And coming to don'ts, if there is a non-filing of claims, we should not consider it as absence of dues. We as RPs should still dig into the books and disclose it in IM, right? See, obviously, if a claim is not filed, it is extinguished, that is clear. But if we know there is a due and if we don't disclose it, then there is a questionable thing on the RP. We have to make adequate disclosures in the IM. Now, it is for the resolution applicant to consider what has to be done. Now, the resolution applicant will write, okay, there are so many dues as per the IM, but only some dues have been received as part of the claims. So this is how we are treating this situation. So then the ball is shifted on the RA. Otherwise, it will always be lying with the RP. It is easier for people to scapegoat the RPs. So RMA in the future can simply come and say that the RP has never informed us about this kind of dues of the employees. Otherwise, we would have made part of the plan. So today we can't do anything about it. So again, the RP is put at the forefront. So we have to ensure that all the claims from the books are duly complied and added to the IM. Now, yes, in terms of PF or gratuity, there cannot be any resolution plan which will have to not which cannot provide for PF or gratuity. So it cramps down every other gratuity. It will have the topmost priority, and any plan where there is a pending PF, PSAC or gratuity dues, the same has to be ensured to be paid in full. Next, um, we cannot assume section 238 to suspend the labor welfare statutes. No, even though section 238 overrides any other law which is inconsistent with the IBC, one cannot assume that labor laws are inconsistent with the IBC. No, labor laws are provided for a reason for running the business. We should not we should not give any scope for yeah, we should not give any scope for any authority to come forward and point out any non-compliance. So therefore, Section 238 cannot be taken as a reliance for mentioning that the law is not applicable. Then wherever we are retrenching employees or closing down the workmen, we should make sure that prior permissions are sought in accordance with the industrial relations code. And whatever pending industrial disputes are there, one should not ignore it. We should take it in record, and if the claims are coming in, we should give some estimated value with reasons. Maybe even at a notional value also is fine, but we should not outrightly reject or not admit the such claims. So this is all about the intersection of labor laws with that of IBC. I tried to point out what all I can where this IBC goes with labor laws. And in tomorrow's session, we will be focusing more on the intersection of IBC with the Companies Act. So that's about it from my side. If there are any questions from the participants, I'll be more than happy to address it. Otherwise, we can conclude the session. Yeah. So, Anjali ji, over to you. If there are any questions from the participants, I will take the same. Yeah. If there are no further questions, we can conclude the session. Anjali ji. Yeah. Anjali ma'am, can we conclude the session, please?
Sir, now can we conclude the session?
Yes, ma'am. We can conclude the session, ma'am. Finish the session. There are no further questions, so we can close.
Okay, okay. Thank you very much, sir, for giving your valuable time and sharing your experience on the topic. And we will meet tomorrow at the same timing at 2:30.
Yeah.
Thank you very much, sir.
Thank you, ma'am. Thanks everybody for joining the session. Thank you.
Thank you, sir.
Thank you, sir. Thank you.